Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. Hi everyone, welcome to this new episode of the Immigration Lawyers Podcast, episode 50, covering events of July 17th through July 23rd. It was an interesting week. We had a lot of little pieces of information that came out from the administration and the immigration news. The primary fun one that opened up actually this Monday on the 24th is that USCIS decided to resume H-1B premium processing for certain cap-exempt petitions, such as those for institutions of higher education, nonprofit related to or affiliated with an institution of higher education, or a nonprofit research or governmental research organization. I know a lot of people that were applying for the H-1B under this status, under the cap exemption, were really worried and having a lot of problems. It's interesting to see that they opened this up. This wasn't the only pullback of the administration with regards to their rhetoric against immigration. They also increased the H-2B visa program to allow additional non-agricultural workers come to the U.S. Both the H-1B and the H-2B are green card or visa types, that the Trump administration, Trump himself that is, has used several times in his organization. So it shows some understanding of the process. We'll see what actually happens in the future as we go forward, especially with regards to immigration regulations and legislation. USCIS also revised Form I-9. So if you're involved in employment-based practices dealing with companies, make sure to have the updated I-9 for your companies, and they adjusted the new instructions accordingly. With regards to CBP, they've now made it so that I-94s will be made available for sea travel in addition to how it was for air travelers. So they'll be able to pull up the I-94 online. Should be really helpful way of having extra documentation when the client loses these documents. One shocker was that, and probably not so much of a shocker, was that the immigration court case backlog hit a record of 610,000. That's a horrible figure to know that that many people are still waiting in line for their removal hearing. And it just means that more and more delays, those multi-year delays until a client could actually get a master hearing. So those are the troubles that are involved with the removal practice. One interesting thing that happened last week was that the U.S. Congress passed the bill to give a green card, lawful permanent residency, to a young child and his parents so they could come to the U.S. for treatment. Long story short, apparently this one baby has severe medical condition, 11-month-old, and in the EU and the courts there, they said this child should be left to die. There's no cures, this and that, so they forbid the family from, keep trying to do procedures that would keep the child alive and potentially controlling them from coming to the U.S. Well, the Congress got word of this, it became big news, and Trump and the legislature decided to issue a green card. So when it comes to practice, it's just interesting to know, we do adjustment of status cases, work-based, employment-based, asylum-based, all that kind of stuff. But Congress could always just pass a bill and issue a law to make someone a lawful permanent resident. So if you have those kind of extreme cases that can get media attention, why not give it a shot and do that and then try to get your client to get a green card? I mean, the hubbub of this started and a week later, the child and the family were lawful permanent residents of the United States. That's one thing. It's with all the things that are happening with the travel ban and attention our practice is getting, definitely keep relationships with the reporters and news people and media people that you meet and talk with. They could always be resources if you have a case where media attention could cause the case to be solved behind the scenes in whatever ways possible. It's kind of a risky maneuver to get them involved, but sometimes in some cases, if the client understands that the risks and approves of it, getting the media involved then could be very powerful to getting the immigration result you're looking for. Moving on from the news, I wanted to first thank Anshu for listening to the podcast and reaching out. A lot of new people who are just starting the immigration practice are listening to the podcast and joining the listserv, and I appreciate all of you, and definitely stay in touch. My email is info@jqqlaw.com. I'd be happy to share information and do whatever help I can. It's really neat to see the number of people getting involved in immigration law, and I see it as a net positive to get people who are dedicated and want to join and have a passion for it. In regard to cases I'm handling right now, a couple of interesting little tidbits and pieces of information that can be helpful for your practice. One was regarding a J-1 visa, where they had the 2-year requirement. Now, we contacted the embassy of the foreign country to request a waiver of the requirements. They have no objection statement from them. And we sent it to the embassy in Washington, D.C. The client followed up 10 days later, and they emailed saying, yes, we approved it. So then we waited a couple weeks, didn't hear anything from the State Department, where the embassy is supposed to send the no objection statement to the State Department for processing. So I contacted the State Department. They say we hadn't received anything. Contacted the embassy of that country, and they say, oh, we emailed them, let me do it again. I said, okay. So we waited another 10 days, contacted the State Department, still didn't get anything. And the State Department said, don't email us, fax us. So we're like, okay. So we contacted the U.S., not the embassy in D.C. They said we'd fax it to them. 2 weeks go by, we hear nothing. So then we contact the State Department. They're like, oh, okay, we got it. The moral of the story is that don't expect the foreign country embassy to do what they need to do. You have to stay on top of it, follow up with them to make sure they're actually sending it, and they're sending it in the appropriate way. I'm guessing fax is the way to go. Email should not be a way an embassy should contact the State Department with regards to J visa 2-year requirement waiver. So at this point, the waiver is sent, was faxed over. State Department confirmed they received it 2 weeks ago, but there's still been no movement on the case. And if we look in the State Department's website, it still shows it's pending, but at least we know it's there. Another problem I've been having, and a lot of you are also having, is the issue of administrative processing when people have security clearance checks, particularly from countries like Iran. So I'm having these cases 14, 15 months, just pushing the issue with the delays. One thing I discovered, which I hadn't used before, is AILA's Special Department of State Liaison. And the requirements for them to follow up on an admin processing case were that you have to have contacted the embassy twice to try to get some movement and shown other activities. So we had contacted them 3 or 4 times to get movement on one case that had been processing for more than a year. And they actually say you can contact the Department of State Liaison for AILA if a case isn't pending for 6 months. So if you do have a case that's an admin processing for 6 months or more, definitely do that. Don't wait till the year mark. But we told them that we had contacted a congressperson, the senator actually, and she said we can't do anything about it. So now we put it in the hands of AILA's liaison service, see what happens. If no movement within the next few months, we're going to be forced to file a writ of mandamus lawsuit. But that's just some information on an additional thing they could do to get the administrative processing potentially finished. But you know how difficult that is. One question I had from everyone who's watching and listening is, how do you consult with a person who's coming to the United States as a tourist, maybe a B-1 visitor, a visitor on business, to do the groundwork for starting an E-2 company with the plan of returning back to home country and then filing the E-2 visa? Now, technically it's possible, and it's intended for use of the B-2 visa to come to the U.S. to analyze business stuff. But I was listening to one recording about an EB-5 session with a couple of attorneys in the AILA National Conference, and they talked about this potentially a client coming with a B-1 with the intent to do an E-2 or EB-5 change later, but just doing the initial groundwork for starting a company or buying a company or anything like that. And they hesitate and they say, well, ideally that's the thing to do, but you don't know with CBP. And so that becomes an issue. I had a client that was about to do this, and I had to really give him a warning of the risks that exist, which they always do with CBP, that you never know if they're going to allow the person to come in or not. It seems like a B-1 coming for an E-2 with the intent and spoken intent, even at the embassy being told that they plan on coming back and doing an E-2 visa later, a full visa. But have you had troubles with this situation? I recently had a case, and this somewhat overlaps, but of a married client that's married to a U.S. citizen, consular processing about to happen, but he wanted to come to the U.S. to help his family adjust before he gets his green card move. So the wife and kids came to the U.S. beforehand, and he traveled with them to help him with the move. And I was really worried CBP would have a problem, and I went and spoke with the LAX office, and they said, no, that shouldn't be a problem. He had a return ticket, had somewhat work back home, and we had paid the visa fee, so it was just a matter of sending some final civil documents in and getting the interview date. And CBP didn't give him any problems, let him in. And so it always worries me, is CBP going to do that or not? It's probably small risk, but if someone does try to come on a B-1 and is denied and they're sent back, then that could be issues for future visas. So it always worries me about giving the advice of coming on a B-1 to research a business. Now, I've seen E2 and E3 cases, Australians do this kind of stuff, and it'd be totally fine. But it's just one of those things that worries me. So if you have experience on this, let me know. info@jqqlaw.com is the email. Moving on, one thing I do, because I do put out a lot of videos, is watch other immigration attorney videos so I could just learn from their skills and things they've talked about. And I was watching one immigration attorney talking about 10 points about, a marriage case and stuff like that. And point number 10, or something like that, was, in his opinion, having an attorney at the interview denotes some sort of apprehension or fraud, or causes the officer to mistrust the client. And I vehemently disagree with that, and I wanted to get your opinions on that. I think if the client can afford it, they should always have an attorney with them at the interview. Whenever you're dealing with the government, and I've said this before, you need to have representation before the power and might of the government, because you never know what kind of officer is. The example I give to clients now is, listen, most of the time you get pulled over by police, it's speeding or something, you just come and go. But we see in the news all the times where a police officer beats the hell out of a person, or plants drugs on him, or gives them a ticket that they shouldn't have given, or just speaks rudely to the driver, scares them. All these kind of things that happen. They're a small number of risks, but they do happen. So if you can afford it, it's always better, even in those situations, wherever, to have an interview present. Now, a traffic stop, it's much more rare for something to happen. But when you're having a benefits interview with the immigration department, for example, marriage case, where you're asking the government to give you a benefit and the officer has full authority not to, I don't see what reason you would have, other than potentially the finances being difficult, to not have an attorney there. I don't think it causes officers to mistrust the case. I think it's just having representation is key. Especially with the way clients under pressure answer questions. They frequently do mistakes, or even say their name's wrong, just because of the intensity of the pressure that's involved in the environment they're in for the interview. So having an attorney present, to me, is, unless the attorney can't afford, is mandatory. Now, in my contracts, I give my clients a way out. I say, if at the time of the interview notice you wish to use my services, that's the time you would pay for me to come, and it's up to you. Now, I'll give a recommendation. For example, if there's been criminal history, their marriage is too short, or has some issues with it, I say, you really need me to come. But sometimes I have clean-cut cases that don't need me, and I let them know, listen, you don't have to have me there. If you could afford it, I'd strongly recommend it. But I give them that leeway. But to issue a blanket statement like, don't bring a lawyer because it causes mistrust, I've had 2 or 3 consultations where people, they don't wanted my advice, but they don't want me to come. And it was mostly for I-751 removal of condition cases. Actually, the 2 that I wanted to do that were people getting divorced, and they wanted to remove conditions based on a waiver. And it was exactly the times you need an attorney, but they were like, no, they're going to mistrust me, or think I'm lying. And the mindset was off, in my opinion. But what's your opinion? Is having an interview mandatory? Is it not mandatory? Do you consider it something you want to avoid because you don't want the officer to judge against your client that they have representation during the interview? And this might be different in different field offices. I know in Los Angeles it's not an issue at all, and I go and they're very friendly and respectful. So let me know what your situation, how you dealt with this in your field offices and in your practice. The last thing I want to talk about is with the idea of marketing and knowing who your client types are. Everyone has a different type of practice, and I've talked about how mine is. For example, I have a low volume practice focused on family and marriage kind of cases and employment kind of cases, and I go for a certain type of clientele in particular. So I have a consultation fee that's relatively high, and it keeps my amount of clients coming in low, and it focuses just on a certain part of the economic financial forum here on the west side. And then I do pro bono stuff on the side to balance it out. But for example, if I was doing removal cases in Los Angeles, I'd want to have an office that's probably a different area of town. Bilingual staff will be necessary and all that. And because of the fact that I don't want to go to court and I don't want to have staff, it makes this kind of practice better for me. But what kind of stuff have you done to focus in and narrow in on the clients you're looking for? So for me, because of the education, financial situation, and type of immigration is needed, my area of the west side is perfect because it fits within the marriage and employment cases I'm looking for. But again, if I wanted to do removal defense, for example, I might want to be in downtown or East LA or that kind of stuff. So it becomes really important whenever you have a practice or any kind of businesses at all to target the audience you're looking for. So when I first started doing my own firm, I was just trying to get everybody. So I have online marketing stuff that's geared towards, for example, asylum, which I don't do now. So I did an article, I did this removal too, where I broke down the LA immigration court, how to get there, what floor it's on, like there's food downstairs, just a complete traveler's breakdown of it. And I did the same for the LA Asylum office. And these are number one first page results on Google now after about a couple of months because of the kind of information I did. But then I saw that this was causing me to get a bunch of cases I didn't want to do at the time. I was thinking about doing full service, but I realized how much resources it takes to have an asylum removal type practice, and I couldn't handle that. So I realized, although the marketing was good, it wasn't the marketing I need. I didn't have an exact idea of how I wanted to talk about this, but I just wanted to bring it up that if you have a practice and you're trying to grow and you're not getting the type of clientele you have, really focus on who the end user is for what you do. Are they athletes? Are they married people? Are they people in your local geographic area? Are they people with your language? And really target who you are and what you do to that group to build on it. Eventually you diversify to other stuff once it gets big enough. But especially if you're starting, really think about what is the type of person, who is the type of person, that family, that business that needs your services. And then fine tune, if you do internet marketing, your marketing presence in the areas they would search with the key terms they would search. So if it was language based, focus on those languages and in the foreign language. Or if it was location based, make sure to highlight that on your website and in searches and profiles that you're located in that area, and you help cities and regions within that specific area. Be as detailed and specific as possible with that. That'll definitely help boost your target audience. I want to thank you for listening to episode 50 of the Immigration Lawyers Podcast. Finally made it to number 50. Looking forward to number 100. And thank you all for listening and keeping this podcast alive. Until next week, bye-bye.